clause of the Texas Constitution. We're not on the record, but if we were, I would be happy to tell you that I do not believe that's what the open courts provision of the Texas Constitution is saying or meaning. But it doesn't hurt to do this. All right. Then let's go ahead and get started. I call cause number 10,836 for the case styled the State of Texas versus Ricky Silva. This is a plea hearing. I base that statement on the scheduling of this matter for this afternoon as a plea. And further, I have been handed plea documents indicating that the defendant desires to enter a plea in this case pursuant to a plea bargain agreement between state and defense. Having explained what type of hearing this is, let me also announce that this hearing is being conducted by remote video teleconferencing technology and is being live streamed on the court's YouTube channel. Those things being done in order to comply with Texas Supreme Court mandates and Office of Court Administration orders requiring same. I think that sufficiently states why we're doing it virtually and not in person. Let me also say that since we are doing it virtually, and it is being live streamed on the court's YouTube channel, I expressly prohibit by court order anyone from recording any portion of this hearing by any means whatsoever, electronic or otherwise, except for the official court reporter for this court, who will record the proceeding just as he would do if we were having an in-person hearing in the courtroom itself. The court reporter is on the virtual, that is the video teleconferencing protocol, so that he can do just what I mentioned. With those announcements, let me call for the parties' announcements. What says the state?
State's ready, Your Honor.
And defense?
Defense is ready, Your Honor.
And the court notices that Mr. Silva is present with us by the same manner and means as everyone else, that is using the Zoom protocol for our virtual teleconference or video conference hearing. Mr. Silva, are you Ricky Silva?
Yes, Your Honor.
Mr. Silva, an indictment has been returned into this court charging you with a third-degree felony offense of harassment of a public servant. You have the right to have someone read the indictment out loud to you here in open court. And so let me ask, do you wish to have someone read the indictment out loud to you?
Yes, Your Honor. Or no, Your Honor.
All right, it's your choice. Do you say no because you already know what the indictment says and what it charges you with?
Yes, sir. Yes, Your Honor.
All right, sir. Knowing then what the indictment says and what the charge is, that is a third-degree felony offense of harassment of a public servant, to the charge in that indictment, how do you wish to plead? Guilty or not guilty?
Guilty, Your Honor.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty, And further, you have the right to not have it used against you or held against you in any way just because you might exercise your right. Do you understand that?
Yes, Your Honor.
You also have the right to have a minimum of 10 days notice of the charges pending against you. I'm looking at your docket sheet as we are talking, and it indicates that you have had more than 10 days notice of these charges. Nevertheless, I would grant to you some additional time if you wish to have it. You also have the right to have a jury trial. And that's true even if you enter a plea of guilty, like you just mentioned that you wish to do. Do you understand that you have the right to a jury trial?
Yes, Your Honor.
Now, I've been handed a document entitled Waiver of Defendant that has a signature that appears to be a signature of Ricky Silva. Let me show that to you and see if I can get it close enough to the camera so you can see that and the signature. Can you see that document?
Yes, Your Honor.
Is that your signature?
Yes, Your Honor.
And did you know by placing your signature on the waiver of defendant document that I just showed to you that you were giving up the opportunity to have more time to prepare, and you were giving up the right to a jury trial, which means we will hear your case today without a jury. Did you know that?
No, yes, I did, Your Honor.
All right. And is that what you still wish to do?
Yes, Your Honor.
Mrs. Fuller, your signature is on this document as well. Is that to evidence that you are joining your client in these waivers?
Yes, sir.
And Mr. Smith, your signature is likewise on the document. Is that evidencing that the state is joining in the waiver of the right to a jury trial?
Yes, Your Honor.
Mr. Silva, it appears that you so much wanted us to accept the waiver of defendant that you also went ahead and signed where the judge signs. But the record will reflect that I'm going to physically mark through the signature that appears to be your signature on the line for the judge presiding, and I will instead sign my name on that line. Is that acceptable to you, Mr. Silva?
Yes, Your Honor.
All right, sir. And just for the record, the court, the deputy sheriff from the sheriff's office who is serving as bailiff has joined us in this proceeding. Mr. Silva, I have accepted the waiver of time and the waiver of a jury trial, but there are other rights and admonitions that I need to discuss with you. Let me start by talking about and informing you of the range of penalties that exist for a third-degree felony offense, such as is charged in this indictment. And so I tell you that a third-degree felony offense carries a range of penalties running from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the Institutional Division, and it also carries the possibility that a fine could be imposed, and if imposed, it would be in an amount not to exceed $10,000. Do you understand that that's the possible range of penalties you face for a third-degree felony offense such as is charged in your indictment?
Yes, Your Honor.
Now then, I understand, and I've already mentioned that I understand that a plea agreement exists between you and your attorney and the state's attorney. But I need to tell you that I'm not required to follow that plea agreement. I am required to tell you if I'm going to follow it or not, because if I decide not to follow the plea agreement, then the law would recognize a new right in your favor, which would be your right to withdraw your plea of guilty. Simply stated, if I don't follow your plea agreement, you can take back your guilty plea. And if those things happen or occur, we will just start all over, and none of this paperwork that you have signed and nothing you have said, such as pleading guilty today, would be used against you. But if I do follow your plea agreement, then you will be bound by the terms of that plea agreement. You will not be able to get out of the terms of the plea agreement just because you don't like them anymore or because you've changed your mind. You would not even be able to get out of the terms of the plea agreement if I follow it by appealing your case. Now, ordinarily, there is a right to appeal, even from a plea bargain case. But if a part of your plea agreement says you give up the right to appeal as a part of the agreement itself, and I follow it, that means you cannot appeal at all. And I'm looking again at your plea bargain agreement, and it says that you are giving up the right to appeal as a part of this agreement. So it means if I follow your plea agreement, you cannot appeal at all. Do you understand that?
Yes, Your Honor.
Then let's go further with this plea discussion. First, let me ask you some questions I'm required by law to ask. Are you a citizen of the United States of America?
Yes, Your Honor.
Where were you born?
Here in Scurry County?
Texas?
Yes, Your Honor.
I know that Scurry County is in Texas, but the black and white record that we're typing out doesn't always recognize it as well as you and I do. So that's why I cleared that up. My next question asks, are you or do you consider yourself presently to be mentally competent?
Yes, Your Honor.
Do you know what's going on in these proceedings at this time?
Yes, Your Honor.
Have you been able to understand the charges against you and the facts that surround those charges so that you could cooperate with your attorney in preparing a defense, as well as, of course, to discuss the case and the facts that surround the case? Have you been able to do those things?
Yes, Your Honor.
Have you been able to receive from her and understand her advice about what the law is and how the law affects your case?
Yes, Your Honor.
Mrs. Fuller, do you believe your client is mentally competent?
I do, Your Honor.
I accept that representation, and it appears to the court that Mr. Silva is also, it also appears to the court that Mr. Silva is mentally competent. It almost came out that I was saying I find that he is also mentally competent, and so who else is it referring to if I find that he is also? So I changed that around to get that correct. Mr. Silva, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, Your Honor.
And let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or that you shouldn't be satisfied. Instead, I asked the question just so you would have an opportunity to tell me if you thought there was a problem with the attorney's work and representation, if there was some deficiency or legal ineffectiveness in her work. If so, I would work to try to correct any such deficiency or legal ineffectiveness if it in fact existed. But I also want to tell you that since I'm giving you the opportunity to tell me now if there's any problem with the lawyer's work, while we can still get that corrected, that effectively means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, now's the time to tell me that if you have that thought at all. Do you understand?
Yes, Your Honor.
And understanding that, are you still telling me you're satisfied with the legal representation you've had from your attorney?
Yes, Your Honor.
All right. Now I'm looking at another document. This one is entitled Written Admonitions on Plea of Guilty. And it just makes me think of another question that I want to ask. Did you have an opportunity to go over these papers with your attorney, to confer with her, get her advice, and even perhaps at sometimes get her direction on how to sign and mark out paragraphs and things of that nature. Did you have that opportunity?
Yes, Your Honor.
And did you do so?
Yes, Your Honor.
And again, are you satisfied with your attorney's help in all of this matter?
Yes, Your Honor.
All right, then let's go a little bit further in this plea discussion. The law also says I must be satisfied that the decision to enter this plea of guilty is your decision, freely and voluntarily made and entered into by you. And so I ask you, has anybody threatened you or forced you or tricked you or in any way tried to make you plead guilty to these charges when you would not otherwise do so?
No, Your Honor.
Has anyone paid you anything or given you anything or promised to give you anything of value just to get you to plead guilty when you would not otherwise do so?
No, Your Honor.
Are you telling me then that you're pleading guilty to these charges because the truth is you are guilty of these charges, and that's the only reason you would plead guilty to such a charge?
That's right, Your Honor.
All right, those are all the questions I have at this moment. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
Defense has no objection, Your Honor.
All right, Mr. Silva, let me visit with you for a moment. I'm looking at the stipulation of evidence form, and it has the signature you've identified as your signature, but it is not notarized. The court reporter who is with us in this proceeding is a notary as well as the official court reporter. Let me ask you in front of him, and by in front of him, I mean in this electronic conference, did you or do you swear that the statements contained in this stipulation of evidence are true and that you signed the stipulation of evidence for the purpose of swearing to the truthfulness of the statements contained in that stipulation of evidence?
Yes, Your Honor.
And is this in fact your signature on the stipulation of evidence? And I show it to you again. Is that your signature?
Yes, Your Honor.
And again, for the record, I showed this to him virtually using the cameras that we're using in our video teleconferencing technology protocol. And so Mr. Hanshu, who has also observed all that we've just done with this stipulation of evidence, will place his signature on the document as the notary, and I will accept. Well, I need to talk to you about the stipulation of evidence. Because there are some other rights and admonitions that exist in or are connected to or surround the stipulation of evidence that I want to make sure you understand. First, let me tell you that the state is required to produce some evidence tending to show your guilt. That's true even if you are pleading guilty, as you have been doing. The reason that's a part of our law is because it helps to ensure that your right to confront the witnesses against you is recognized and provided to you. Now, the right to confront the witnesses that belongs to you is your right to require the state to bring those witnesses into court, to have them sworn in and testify in front of you so you could see them, even if it were done through the video camera like we're doing now in this virtual hearing. You would have the right to have them testify so you could see them and hear them as they gave their testimony. But this stipulation of evidence says you're giving up that right And thus you're telling the state they don't have to bring their witnesses into court at all. Did you realize you were giving up the right to confront the witnesses against you when you signed the stipulation of evidence?
Yes, I did, Your Honor.
All right, sir. Now, let me also tell you that the stipulation of evidence says you're giving up your right to remain silent and you're giving up your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. But by signing this stipulation, you are giving evidence against yourself. The stipulation document itself says that you judicially confess that all of the material allegations set out in the indictment are true, that you committed the offense just like it claims. Did you realize you were confessing or admitting this offense when you signed the stipulation of evidence?
Yes, Your Honor.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rests, Your Honor.
Defense would rest, Your Honor.
State closes.
Defense would also close, Your Honor.
All right, Mr. Silva, the next thing I want to discuss with you is the plea bargain agreement itself. We've already been talking about it as something in existence, but let me talk to you about what it says just to make sure that you and I understand the same thing as to what it says. My understanding of what the plea agreement says is that you will plead guilty to this charge as you have been doing, that will result in a 5-year sentence to the penitentiary, but that sentence to the penitentiary will be probated and you will be placed on probation. Further, that probation will be a deferred adjudication probation, which means I need to discuss that with you also. But it's the plea agreement also says you will be assessed a fine of $1,500. You will be ordered to pay court costs in the sum of $290. And you will be ordered to pay reimbursement fees totaling $675. The plea agreement says you will waive your right to appeal, as I have already discussed that with you. And while on probation, you would participate in what we call the Treatment Alternatives to Incarceration program, also known as the TAP, T-A-I-P program. And that program is, first of all, an assessment to determine if you have drug or alcohol related problems. And if you do, then there will be treatment and or counseling options made available to you thereafter. Now, those are my understandings of the basic terms of the plea bargain agreement. Is that the same as your understanding of the basic terms of the plea bargain agreement?
Yes, Your Honor.
Now, I also mentioned that the plea agreement says your probation would be a deferred adjudication probation. Let me tell you that the law requires me to tell you that there are benefits and there are detriments, positives and negatives, if you will, to a deferred adjudication probation. Now, I'm confident your attorney has already told you all of these things, but the law says I must tell you, and so I will do it as well. The easiest way I have found to explain the benefits of a deferred adjudication probation is to just define the terms. Deferred means put off to a later date. And so we might ask, what is put off to a later date? It is the adjudication. So what is the adjudication? Adjudication is the decision making, and the decision would be whether to find you guilty or not. And so the decision to find you guilty is deferred to a later date while you're on probation. Probation is a requirement that for a period of time you follow certain rules. If you follow all of the rules of probation, your finding of guilt, which will be deferred if I follow your plea agreement, which will be set off to a later date, If you follow all the rules of probation and finish your probation without getting in trouble, then that finding of guilt will have never been entered, and you will be legally and factually correct in saying that you have not been convicted of this offense. That's a benefit, a big benefit. And you need to be diligent in making sure you follow all of the rules of probation to make sure you get that good benefit. But there are negatives as well, or detriments to a deferred adjudication. One of them is that the state of Texas, who set up this whole deferred adjudication probation idea, they say, even though it's not a conviction, we, the state of Texas, can take it into consideration just as if it were a conviction and refuse to grant you certain licenses, such as the professional license to be a nurse or a lawyer or a doctor or a plumber. So the state could deny you some licenses because of a deferred adjudication probation. That's a detriment. It's possible that a private employer or a private company might find out that you have deferred adjudication probation. They really shouldn't be able to, but sometimes that's something that they are able to do. And they might misunderstand and think it is the same as a conviction and thus refuse to give you employment, or maybe to advance you, give you promotions after you've already started to work. Those are detriments. But I think the biggest detriment of all is if you violate your probation, if you don't follow all the rules of probation, and the state files a motion claiming you violated your probation, you will be entitled to a hearing. And after a hearing, if the state proves that you violated your probation, the court, the judge, could consider the full range of penalties and assess your penalty, your sentence for violating your probation anywhere within the range that I have discussed with you. That means it's not limited to 5 years in the penitentiary. If you violate your probation, you're looking at the entire range from 2 years to 10 years and a fine all the way up to $10,000. That certainly is a detriment as well. And so let me ask you, do you understand that there are both benefits, positives, and detriments or negatives to a deferred adjudication probation?
Yes, Your Honor.
Knowing that, and knowing the terms of probation that you and I have discussed, do you want me to approve your plea bargain agreement?
Yes, Your Honor.
All right, sir. Mrs. Fuller, have I stated the plea agreement accurately as you understand it to exist?
You have, Your Honor.
Mr. Smith, have I stated the plea agreement accurately as the state understands it to exist?
Yes, Your Honor.
All right, I state on the record, Mr. Silva, that I will accept and follow and approve your plea bargain agreement. And so I need to tell you what that results in. In cause number 10,836, which is the case style, the state of Texas versus Ricky Silva. Mr. Silva, based on your plea of guilty, based upon the evidence you stipulated to, I find that the evidence is sufficient to find you guilty of the charge in the indictment of harassment of a public servant. But I'm also saying, and I will follow your plea agreement, which means I do not enter the finding of guilt at this time, even though the evidence would support that. And instead, I defer that, put that decision off to a later date to see if you will follow all the rules of probation. And if you do follow all the rules, then I will never enter the finding of guilty. And as we've already discussed, you would be able to correctly say that you have not been convicted of this charge. That said, you have to follow the rules of probation. So let me ask you, do you know what the rules of probation are that you'll have to follow?
Yes, Your Honor.
Did you have a chance to go over those rules with your attorney?
Yes, Your Honor. A little bit.
All right. So let me ask you, can you follow these rules?
Yes, Your Honor.
Will you follow these rules?
Yes, Your Honor.
And I ask it that way because if you cannot or will not follow the rules of probation, then you're not likely to be allowed to stay on probation. Do you understand that?
Yes, Your Honor.
All right. Now then, another question. Are you able to read and write the English language?
Yes, Your Honor.
Good. That means I don't have to read these rules to you. Instead, I'm going to cause a copy of the rules and the judgment itself to be given to you so that you will have those with you and you can read those rules anytime and as often as you wish to. Now, let me also tell you that as per your plea agreement, I'm assessing a fine of $1,500 and ordering you to pay court costs in the sum of $290, as well as to pay reimbursement fees totaling $675. But we're going to talk about those financial obligations when we talk about the rules of probation just a little bit more in detail. Since you can read and write the English language, as I've already mentioned, I'm not going to read the rules to you, but I do want to mention some just for emphasis. First, don't break the law. Not here or anywhere else. You cannot expect to stay on probation if you're out there breaking the law. Next, stay away from drugs and alcohol in any form. Don't go to places where drugs or alcohol are sold, served, consumed, or possessed. That means what it says. We find more people violate their probation and lose the benefits of probation because they are using alcohol or illegal drugs. So stay away from those and stay away from the places where those are found. I will make 3 exceptions. You can go into a grocery store, for instance, to buy food, even though they sell alcohol in the grocery store. So that's an exception, but you can't buy the alcohol or possess it or consume it. Also, I'll make an exception. You can go into a convenience store to buy items in a convenience store, or usually most people end up buying gas for their automobile at a convenience store. So you can go there to do that. You just can't get the alcohol or possess it or consume it. And finally, as an exception, you can go into a restaurant without being in fear that you would accidentally or unintentionally walk into a place where alcohol is being served. Since not every restaurant tells you that they're selling alcohol inside, I make that exception. You can walk in there and not have to worry that you might have just unintentionally violated your probation. But again, you cannot have the alcohol, you cannot possess it, consume it, or purchase it, nor can you be with other people who are doing that. While on probation, you will report to the probation office once a month, at least once a month, and you'll do so here at the probation office in Snyder, Texas. Do you know where the probation office is?
Yes, Your Honor.
All right, you'll go there before the 5th day of each month unless you and your probation officer set up a different day for you to report. The papers that I have been handed for your plea today says that you live at 4002 Austin Avenue. Is that correct?
Yes, Your Honor.
And that's here in Snyder, is that right?
Yes, Your Honor.
You will continue to live there and not move to some other address unless you get written permission from your probation officers. Now, let me tell you that that's not hard to get. They're not going to try to keep you from moving. They just want to know where you are, and they want to make sure you're not moving into some place that will cause your probation to be in trouble. Does that make sense?
Yes, Your Honor.
All right. Now, the financial part of your probation, I've already told you the fine and court cost and reimbursement fees, all of those total $2,465. I have in front of me a document that says you are asking permission to pay that total at the rate of $45 per month. Is that what you're asking?
No, Your Honor.
What are you asking?
I don't have a job, Your Honor.
You're asking not to pay?
No, I'll pay, but I'm going to have to find a job first, Your Honor.
Well, we don't really work that way. One of the rules of probation is that you get a job.
Yes.
So you have to do that anyway. You also have to pay a $60 per month supervision fee. Those two total $105 each month. So let me ask you, do you have the ability to get a job?
Yes, Your Honor.
Do you have the, and by ability, I mean both the physical and mental abilities to get a job and hold a job that would earn enough money to allow you to make these payments, plus take care of all of your own needs? Do you have that ability?
Yes, Your Honor.
And are you in the process of preparing to do that as soon as possible?
Yes, Your Honor.
All right. And with that, is that what you're telling me, or these papers are telling me you're asking permission to pay all of these obligations on a monthly basis instead of in one lump sum payment today?
Yes, ma'am. Yes, Your Honor.
That's all right. All right. I'll approve that, but that's going to be a term of your probation. And you'll have to start making these payments with your payments due, with your reporting that's due in February. Let me tell you that while you're on probation, you will have to observe a curfew. There are some exceptions, but basically you have to be in your home by 10 o'clock each night, and you can't leave before 6 a.m. the next morning, unless you're going to and from work, or you have an emergency, or you get permission from your probation officer ahead of time. Those are the exceptions. You cannot leave your home county, which we've already established is Scurry County. I don't know that we established that as your home county as much as we did that was your birth county, but your address is in Snyder, Texas, Scurry County. Is that right?
Yes, Your Honor.
So you will not leave Scurry County for more than 3 days unless you get permission first from your probation officers. You will perform 160 hours of community service restitution, and you will do that at the rate of at least 10 hours per month. And then you will come back to see me on the 15th day of April. Of 2021 for a probation performance review. It's a time where I check to see how you're doing on probation. As long as you're doing everything you're supposed to, we will say, good for you, that's what you're supposed to do. If you are not, then we will attempt to redirect you, even to provide some sanctions short of revoking your probation to try to get you to perform all of your rules of probation. One of them will be to try to make sure that you are wide awake anytime you come to court. Okay? Now, I have 2 sessions on the 15th of April, one at 1:30 in the afternoon, the other at 9:30 in the morning. Do you have a preference? I will give you a choice as to whether you come to the session in the morning at 9:30 or the one in the afternoon at 1:30. What is your choice?
The one in the afternoon at 1:30, Your Honor.
All right, sir. I will accept that. I will write it in, and it becomes a term of your probation. You have to show up. And there will be others after that, but I will let you know each time you report. And we'll make them less and less frequent, further and further apart, as long as you're doing well. And we'll make them closer together if you're not doing well. until we are satisfied that you no longer need that kind of close supervision. All right, sir. Those are not all of the rules of probation, but they're just the ones that I like to emphasize because I have seen those rules cause people most often cause people problems. But since I haven't mentioned all of the rules, let me give you a chance to ask any question you have about any of the rules. Do you have any questions about any of the rules of your probation?
No, Your Honor.
All right, sir. Those will be the orders of the court. Your thumbprint will be required to be placed on the judgment. The bailiff will see to that in just a few moments. Just stay in the room that you're in and someone will come to you. Mr. Oliver, when do you want Mr. Silva to report for the first probation report?
Sorry, I'm trying to unmute. It wouldn't work. He needs to report immediately to see
Okay,
Miss Duggan.
that means, Mr. Silva, when you're finished getting your fingerprint or your thumbprint on this judgment, you will then go across the street to the probation office and see Miss Duggan in the probation office. And that will be your first report. She will give you a copy of your rules of probation at that time. Now, once again, do you have any questions?
No, Your Honor.
Very good. I wish you well, and we'll be in recess. Mr. Smith, I need to see you on a matter. I'll be there or have someone there in just a moment.
All right.
Thank
Miss
you.
Fuller,
Sir?
Jeannie, after Mr. Silva's off the screen, I need to bring something to your attention right quick.
But
Yesterday in pre-trials, Jane Gutierrez, I believe, was one of your clients.
Mm-hmm.
She represented that she has been reporting for bond supervision, but just hasn't paid yet.
Yeah.
She has not reported for bond supervision since October.
Whoa.
Just wanted to make you aware.
I'm actually visiting with her today.
Okay.
in other words, she's fixing to have her warrant recalled
Recalled?
and put back in jail
Oh,
unless she gets to the probation office and reports.
okay. Let me see what's up with that.
Thank you, ma'am.
Thank you.
Mr. Smith, did you do an order of dismissal in that other case of Mr. Keith's?
Oh, Massengill. No, I haven't, but I will.
We told him that since you didn't present it during the plea, that meant you were prosecuting it. We'll probably go to trial the second half of the week in January. He said he would get in touch with you, but I told him I would go ahead, and I was sure that was a part of the plea since he represented that it was, and that you would get that. Now, one other thing, Ben, I don't find among the plea papers the approval signature page unless for the stipulation of evidence. Also, the stipulation doesn't have it does. Terry just put a stamp on it, but I don't have the signature page approving
Okay.
the stipulation.
Would that be, and it may be since we emailed it to Jeannie more than once and probably got lost in the shuffle somewhere. We'll bring you one.
Okay.
I'll bring it right up.
Well, Terry may be coming down there.
Okay.
I'm not sure why he started to come down there. And so I don't know if he's coming or not. He found what he was looking for, so he may not be coming after all. Anyway.
Did you get what you needed? No. Okay. He's here. We'll get it to him.
Okay. Thanks.
Thanks, Judge. All right.
Have a great weekend.
You too.